Hello. Welcome to a podcast on the law and its impact on computing technology and business. This is Brian Gaff. I'm a senior member of the IEEE and partner at the Edwards Wildman Law Firm in Boston. The IEEE is presenting this podcast in conjunction with a series of articles that I co-authored on legal issues relevant to people in the computer hardware, software, networking, and service businesses. These articles are appearing in the IEEE's computer magazine each month in 2012. This podcast is part 2 of our series. In the last podcast, we discussed the different types of intellectual property, or IP, protection. In this podcast, we will cover the enforcement of IP rights. Joining me today for this podcast is my colleague, Ralph Lauren. Ralph is also an IP partner in the Boston office of Edwards Wildman Palmer. Welcome, Ralph.
Thanks, Brian.
So, Ralph, when someone believes that their IP is being used without authorization, that another party is infringing their IP, what should they do?
The first thing that an IP owner should do is to conduct a thorough investigation to confirm that his patent, trademark, copyright, or trade secret is being infringed. This can be harder than it sounds. The law is very specific about what someone can and cannot do with another's IP. For example, certain activities may be considered infringement only if they occur in the United States. The law may excuse other activities as fair use of the IP. Given these complexities, is it advisable to work with an IP attorney during the investigation, or at least have an IP attorney review the results of the investigation? Before reacting too strongly to a perceived infringement, carefully look into the facts and the applicable law. About the last thing you want to do is falsely accuse someone of infringement. Anyone on the receiving end of an allegation of infringement, irrespective of whether it's a valid allegation, can usually initiate a lawsuit against the accuser that asks the court to rule on the allegation and proclaim that the IP at issue is invalid or unenforceable.
What you're talking about are declaratory judgment lawsuits. I've seen many instances where an IP owner mishandles an allegation of infringement, and the result is that the IP owner gets sued.
That's right. In those cases, the IP owner is put on the defensive and has to deal with a lawsuit that's filed on someone else's terms. That's not an ideal situation.
Assuming that the IP owner has done the proper investigation, consulted with an IP attorney, and concluded that there's an infringement, what should he do next?
In almost all cases, the IP owner can file a lawsuit against the infringer. However, whether the suit gets filed in federal or state court, or whether the IP owner can have an administrative agency resolve the dispute instead of filing a lawsuit, depends on the type of IP infringed. For example, an IP owner would address the infringement of a patent or copyright by filing a lawsuit in United States Federal District Court. In the case of trademark infringer, the IP owner could file suit in either federal or state court, depending on the circumstances. In matters involving the misappropriation of trade secrets, it's not unusual for the IP owner to file a lawsuit in state court.
Okay, so if the IP owner decides to file a lawsuit, he will then have to have his IP litigation attorney prepare a complaint, file it in the appropriate court, and serve a copy of it and a summons on the infringer.
Correct. And the IP owner also has to pay the court's filing fee, which is typically a few $100s. The infringer has 21 days from the date that he's served to respond to the complaint, and after responding, the litigation gets away in earnest.
Let's assume that the IP owner wants or has to file the lawsuit in U.S. Federal District Court. There are almost 100 of these courts around the country. How does the IP owner choose one?
The U.S. law sets limits on where lawsuits can be filed. Generally, for a lawsuit filed in a U.S. Federal District Court, that court must be located near where the defendant, the accused infringer here, has an office, is incorporated, or has engaged in the infringing activities. Typically, this requirement sharply reduces the number of courts where the IP owner could file, but there will always be at least one court in which it is possible to file. If there's more than one, the IP owner should consider other factors in making a selection, such as the court's caseload and how it handles IP disputes before making that selection. Of course, the accused infringer, once sued, could ask the court to transfer the lawsuit to another location, and the court could grant that request over the IP owner's objections.
Every court is different in how long it takes for an IP dispute to get to trial. You and I have both litigated IP cases and have seen extremes where the time between filing a complaint and getting to trial could be less than 1 year or more than 3 years. What's your current take on the time needed to litigate an IP case?
It really does vary from court to court. Some federal district courts, like those in Massachusetts or certain parts of California and Texas, have instituted special rules for handling IP cases, particularly patent infringement cases. Those rules help streamline litigation and get the parties to trial sooner rather than later. Other courts have no special rules for IP cases. If I were to estimate, I say that today an IP owner should expect to wait 2 to 3 years after filing a complaint to get to trial.
The percentage of IP cases that actually get to trial has traditionally been very low.
That's correct. Most IP lawsuits never get to trial. The parties settle sometime beforehand. It is common that while a litigation is proceeding, the parties have on and off discussions about settlement. Sometimes those discussions are more formal and involve a mediator. In most instances, usually as a result of business considerations or a ruling from the court on an important issue before the scheduled trial date, the parties agree on a settlement, ending the litigation.
Earlier you mentioned that an alternative to filing a lawsuit is for the IP owner to have an administrative agency resolve the dispute. Can you explain that option?
Sure. In the United States, there are administrative agencies that are set up to resolve disputes involving certain types of IP. One of the most widely known of these agencies is the International Trade Commission, or ITC. IP owners can bring allegations of, for example, patent infringement, trademark infringement, copyright infringement, or misappropriation of trade secrets to the ITC for resolution. However, these allegations must relate to goods imported into the United States to bring it in the ITC. The ITC can be involved when a U.S. industry that exists or that is being established is threatened with the importation of goods that infringe U.S. IP. Therefore, if one imports a product into the United States that infringes a U.S. patent, the owner of that patent could ask the ITC to investigate. After investigating, the ITC could choose to conduct what amounts to an expedited trial on infringement and then render a decision. The ITC works fast. The entire process usually takes less than a year. That's much quicker than the corresponding action filed in U.S. Federal District Court. While the IP owner may find this rapid resolution attractive, it is important to keep in mind that going to the ITC for relief is not an option when the infringement does not involve importation and injury to a U.S. industry. In addition, there is no possibility of damages at the ITC.
Disputes over Internet domain names can also be handled administratively, right?
Yes. The Internet Corporation for Assigned Names and Numbers, known normally as ICANN, has a Uniform Domain Name Dispute Resolution Policy, or UDRP. That policy provides a way to resolve allegations of abusive registrations of domain names without litigating. The UDRP is commonly involved in cyber-squatting disputes as an alternative to filing a lawsuit. In those cases, the IP owner, typically is normally someone who has a registered trademark, and alleges another is using that trademark as part of a domain name. Rather than filing a trademark infringement lawsuit against the domain name owner, the IP owner follows the UDRP. This usually takes less time and costs less money than a litigation.
It's pretty clear, then, that an IP owner has many options to choose from when it comes to enforcing IP.
Correct. The costs and timelines for each vary widely, and those usually factor into which option the IP owner chooses. Of course, the facts and circumstances of the case and the applicable law could limit those options.
Thanks, Ralph. It's clear that this is a complex area of the law where an IP owner needs to tread carefully only after getting proper legal advice from an IP attorney. We hope that you found this podcast helpful in understanding enforcement of IP rights. Stay tuned for our next installment in Computer Magazine, which will cover the legal aspects of data security and privacy. Until next time, this is Brian Gaff
and Ralph Lauren.
Feel free to contact us via email at bgaff@edwardswildman.com
or at rlauren@edwardswildman.com.
Thank you.